After hearing the submission of the Learned Council for the parties at some length, we find that the relevant statutes are 710 and 713 of the Statutes of the Purvanchal University, which is pari materia to the statutes 15 and 15 of the Mahatma Gandhi Kashi Vidyapeeth Varanasi, Statute 17 of Purvanchal University and Statute 15 of Mahatma Gandhi Kashi Vidyapeeth indicate that seniority list has to be made on the basis of substantive appointment. Statute 17 of Purvanchal University and Statute 15 of Mahatma Gandhi Kashi Vidyapeeth indicate that if substantive appointments are made on the same date, in which case the seniority would be considered on the basis of seniority in age. In view of the said provisions, we find that in the instant case, the substantive appointment of the petitioner and the respondent number 6 was made on 22 November 1991. Since both were appointed on the substantive post on the same date, the seniority list is required to be considered in the list of the provision of the Statute 17 of Purvanchal University read with Statute 15 of Mahatma Gandhi Kashi Vidyapeeth. The petitioner was born in the year 1956 in comparison to the respondent number 6 who was born in the year 1963. We find that the Chancellor monitored the petitioner on the ground that no objection was raised by him or by Vinod Kumar Rai for 17 long years. The Committee of Management contends that the seniority list was prepared by the principal of the institution in the year 1993, which was sent to the university, and no objection to it was filed by any of the teachers, including that of the petitioner, and therefore at this belated stage, no changes in the seniority list could be made. The Chancellor as well as Counsel for the respondents have placed reliance upon a decision of the full bench of this court in Dr. Asha Saxena versus Srimati S.K. Chaudhary and others 1991 on the proposition that the seniority list could not be challenged after a lapse of 17 years. We find that there is no controversy of the proposition advanced in the aforesaid two cases. We are of the opinion that these decisions are not applicable in the instant case. We repeatedly asked the Learned Council for the Respondents Committee of Management as well as Council for the Respondent number 6 to indicate and produce any document by which the court could find that the seniority list prepared in the year 1993 by the principal of the institution was circulated to the teachers and whether any objection was invited by the institution. We are constrained to observe that the Committee of Management and the institution in question have not filed any counter affidavit, and the counter affidavit of the respondent number 6 is silent on this issue. We can consequently assume that the seniority list prepared by the educational institution in the year 1993 was never circulated, nor objections were invited from the teachers, and consequently the petitioner could not be non-suited on the ground of delay. On the other hand, we find that the Director of Higher Education issued a letter dated 1 September 2006 modifying the seniority list, in which it was indicated that the respondent number 6 is the senior most on the basis of initial appointment made on 7 March 1989 and indicating the petitioner's appointment as 13 March 1989. We find that the seniority list on the basis of the initial appointment on ad hoc basis cannot be made in view of the specific statutory provisions, namely Statute 17 of the Purvanchal University and Statute 15 of the Kashi Vidyapith. In the light of the aforesaid, we are of the opinion that the order of the Chancellor dated 15 October 2010 cannot be sustained and is caused. In our opinion, the order of the Vice Chancellor is perfectly correct and in accordance with the provisions of statute. We accordingly hold that the petitioner is senior to the respondent number 6. The writ petition stands allowed.